What's up, guys? This is Manoj Bhuptani. I welcome you all on behalf of the Edupedia world. It's been a fantastic morning outside, and I'm sure that you guys must be loving your day thoroughly, completely. So, in my last presentation, we were discussing a few relevant topics relating to the Insurance Regulatory and Development Act 1999. This is the forthcoming presentation of that particular stuff, wherein I'll be discussing with you the remaining topics of the IRDA Act 1999. So by now you must have revised your complete topics that were covered in the last video. I'm sure you must have done. So with that kind of hope, belief, enthusiasm and spark, let's create the same magic in this particular presentation as well. Fasten up your seatbelts. We are about to take off with the remaining topics of IRDA Act 1999. Are we all set? Let's go. Restriction on employment of chairperson and other members in certain cases. This thing has been mentioned under Section 8 of the IRDA Act 1999. So like any other authority, if I'll talk about IRDA, even IRDA is having some of the restrictions on its core management people. Okay. What they say is that once you have been employed with IRDA as a chairperson or as a whole-time member, then in that case you just cannot accept any of the employment, be it from central government or state government or any other company who has its business in the insurance sector. They have provided this restriction, and each and every chairperson and each and every whole-time member have to abide by that restriction. What is the lock-in period for that? That's the time period for that restriction will be 2 years from the date when that chairperson or whole-time member is going to cease from that office. Okay, so 2 years from the date of cessation of that office is the time period of that restriction. This thing has been mentioned under Section 8 of the IRDA Act 1999. What Act says basically that chairperson and whole-time directors not to accept any employment either under state government or under central government or any appointment in any company in insurance sector. And the time period will be 2 years from the date of cessation. There is no such kind of restriction which has been imposed on part-time members. So since it has not been mentioned in the BARE Act, so they are free to accept any of the employment once they cease to be associated with that office of authority, that is IRDA. So this is something which was about restriction on employment of chairperson and other members in certain cases. This thing has been explained under Section 8, and I hope you guys have got the complete understanding with respect to the same. Shall we proceed further? Obviously, we'll have to. Perfect, guys. Let's move towards the next topic. And this will be about the meetings of authority. Now something about the meetings. Okay. This thing has been mentioned under Section 10. So here we'll discuss about 3 major topics. 1. Number of meetings and procedure of meetings. Number 2. What will be the effect of absence of chairman? That will be covered under Section 10, subsection 2. And what about the decision by majority? That will be covered under Section 10, subsection 3. So are you guys all set? Let's mark the beginning with number 1 point. That is the number of meetings and procedure of meetings. So the authority, that is IRDA, shall meet at such times and places and shall observe such rules and procedures in regard to transaction of business at its meeting. So they are going to decide, the members, the composition of IRDA, that how many times they want to meet and what all matters are they going to discuss in that. So there is no fixed ceiling, minimum limit as to the authority needs to meet at so many times in a year. That's the minimum limit. That hasn't been fixed by the authority. Okay. So the authority shall meet at such times and places and shall observe such rules and procedures in regard to transaction of the meeting, which has been determined by the regulations. So what are the regulations say? They usually get changed from time to time. Accordingly, the authority needs to fix up the meetings and procedures of those meetings. That is something which will be covered under Section 10, subsection 1 about the number of meetings and procedure. If I talk about the absence of chairperson. So, the chairperson, if let's suppose for any reason, is unable to attend the meeting of the authority, then any other member chosen by the members present amongst themselves at the meeting shall preside the meeting. So, in the absence of any person who is a chairperson, so there will be another member who will be chosen by the members who are present in that meeting. From amongst those themselves, they are going to select one person and he or she shall be the person who is going to preside at the meeting. So that's going to happen if in case the chairperson is just not available. This is something which has been mentioned under section 10 subsection 2. Now the last part, that is the decision by majority. So all questions whichever come up before the meeting of the authority shall be decided by majority of votes by the members present and voting. And if in case it happens to be a chance wherein there is equality of votes, then the chairman, or in his absence, the person who will be presiding, shall have a second or casting vote. So if in case it's an equal counting, then chairperson or the person who took up the chair except the chairperson is going to have the benefit of availing the benefit of the second or casting vote in that case. So all questions whichever come up, they are going to be decided by majority of votes. Decision has to be taken by majority. This thing has been mentioned under section 10 subsection 3. So what did we understood with this provision? That the number of meetings and procedure of meetings shall be decided by the regulations that will keep changing from time to time. If in case the chairman is just not available, then another person who will be chosen by the person who are being present in that meeting, that one person is going to preside over the meeting. And all the decisions whichever being taken up, they will be taken by majority of votes. And if in case there is an equality of vote, then the chairperson or the person who will be presiding in the absence of chairperson is going to have a second or a casting vote. And that's how he is going to provide the decision by majority. These things were mentioned under section 10 of the IRDA Act 1999, and I'm sure that you guys have a complete understanding with respect to each one of these three provisions. Shall we proceed? Perfect guys, let's move further. Next topic, and this will be on vacancies, etc. not to invalidate proceedings. This is something which has been mentioned under section 11 of IRDA Act 1999. So guys, this particular section simply says that if in case there is some kind of vacancy, or if in case there is some kind of defect in the constitution of authority, okay, or if there is any kind of defect in the appointment of the person acting as a member of authority, be it chairperson, be it whole-time member, be it part-time member, or if in case there is some kind of irregularity in the procedure of authority not affecting the merits of the case, then if all these things are going to happen, okay, that does not going to impact the kind of act or proceeding which has already happened, and they won't get invalid merely because of these reasons, that there is some kind of vacancy or defect in constitution, there is some kind of defect in the appointment of the chairperson or whole-time member or part-time member. So whatever the kind of act or proceeding the authority has done on their behalf, they have been a part of it. So all those acts and proceedings shall remain valid. Okay, they are just not going to get invalid merely because of these stuff. This is something which this section actually says, and that's actually right. Let's suppose for the past 5 years, okay, there is a chairperson whose appointment has some of the defect. Okay, he passed out so many things. Okay, he did so many proceedings on behalf of authority, and all that stuff was done. Okay, now since you got to know that there was a defect in the appointment of that person, now all those acts which have already been completed for the past 5 years, are you going to ensure that they remain the same as they require to be have some kind of retrospective effect? Absolutely not. That's just not feasible. Okay, something has already been committed. All those proceedings and acts have already been done. So they are not going to get invalid merely because of these reasons. So no act or proceeding of the authority shall be invalid merely by the reason of any vacancy or defect in the constitution of authority, or any defect in the appointment of a person acting as a member of authority, or any irregularity in the procedure of the authority not affecting the merits of the case. So if anything happens, so vacancies or these stuff is not going to invalidate the proceedings. This is what this particular section, that is section 11, talks about. I'm sure that you guys got a complete understanding with respect to this section as well. So next time whenever you come across any of the situation wherein question it's asked the appointment was defective, so whatever the kind of proceedings and acts or results or verdicts that have been delivered by the chairperson, are they going to be invalid now? So no, that's not going to be invalid merely because of his defect in appointment. So I hope you guys are pretty much clear with each and every kind of stuff that I told you up over here. Perfect. Can we proceed further? Absolutely, we'll have to. Let's move further with the last topic of this presentation and the last topic of this chapter. And this will be on the powers of central government to supersede authority. It's been said every father has a father who is known as grandfather. So here the grandfather is central government. So central government has got the power to supersede the authority, and what all will be the instances wherein central government can supersede the authority. Let's discuss about those instances and what will be the conditions and what will be the effect of that supersession. Let's understand it completely by digging it a bit further. Are you guys ready? Perfect. Let's move forward. This thing has been mentioned under section 19 of IRDA Act 1999. Number 1, reasons for supersession. So what will be the reasons for that supersession? So this has been mentioned under section 19 subsection 1. The number 1 will be circumstances beyond control of authority. Let's suppose there's arose a certain kind of situation wherein the circumstances went beyond the control of authority. Now the father has to come, the grandfather needs to enter into that space. So then at that moment of time, central government has the power to supersede the authority once the circumstances went beyond control of authority. Next, the IRDA authority is persistently defaulted in complying with requirements of law. There could be a situation wherein the authority is like persistently defaulting with the compliance of the act. Then again, that's one of the reasons of supersession. And finally, if circumstances exist which render it necessary, then again, it will be the call of central government to choose and fix up with the supersession over the authority. So, what BEREX says. Now, this is something which I provided to you in a very simple language. Circumstances beyond control, authority persistently defaulted in complying, and if circumstances exist which render it necessary. But what does BEREX says on that? So, BEREX simply says that the central government may supersede the authority if it is of the opinion that on account of circumstances beyond the control of authority, it is unable to discharge the functions or perform its duties imposed on it. Number 1. Number 2, it is of the opinion that the authority has persistently defaulted in complying with any direction given by central government under this act or in the discharge of the functions or performance of its duties imposed on it. And as a result of such default, the financial position of the authority or the administration of the authority has suffered. Or if it is of the opinion that some certain circumstances exist which render it necessary in public interest to supersede the authority, then it is under the power of central government to supersede authority if in case any of these 3 reasons do happen. I'm sure that you guys are clear with the kind of reasons I have kept it over here. This thing has been mentioned under section 19 subsection 1. Now, moving to the second part, that is the conditions for making a supersession. Central government shall be required, number 1, to issue a notification, stating therein the reasons for supersession. You need to record your reasons in writing. So, central government is required to issue a notification in which it will state the reasons for supersession, why supersession was done, and the period of supersession. Till how long are they going to take care of the affairs of that complete authority? Till what time? So, what will be the period of supersession, which shall not exceed 6 months? Let's suppose there is a temporary kind of stuff which is required and central government needs to come in the front and keep authority a little back. So, what's going to happen? It may be happening for a period of supersession which shall not be exceeding 6 months. 6 months is the maximum period of time, till when the central government has the power to supersede the authority. Beyond that, it's not. So before issuing any such notification, what's going to be happening? Central government shall issue notification only if in case a reasonable opportunity of being heard or to make their representation against the proposed supersession has been provided to the authority. And it shall consider the representation, if any, of the authority. It is likely and it is compulsory for central government to address their reasonable opportunity with respect to making the representation, and they shall consider those representation, if any, made by the authority. Central government shall appoint a person to be a controller of insurance under section 2B of the Insurance Act 1938, and he shall take care of all the kind of things of supersession with respect to the authority. So are we guys clear with that? Perfect. Let's move towards the effect of supersession. So what's going to be the effect of supersession? This has been mentioned under section 19 subsection 2. So, upon the publication of notification under section 19 subsection 1 superseding the authority, the chairperson or other members shall from the date of supersession vacate their offices. All the chairperson and members shall vacate their offices from the date of supersession. That is number 1. Second, all the powers, functions and duties which may be exercised and discharged on or behalf of authority shall be discharged and exercised now by the controller of insurance, the one who has been appointed by central government. Okay, that person is going to take care of all those powers, functions and duties. Okay. Number 3, all the properties which were owned and controlled by the authority shall now be vested in the central government. These will be the effects of supersession. Chairperson and the other person will vacate their offices. Now, controller of insurance is going to take up the charges of all the powers, functions and duties with regarding to the authority, and all the properties which were owned and controlled by the authority will now shall vest in the central government. Are we guys clear with that? Perfect. Now let's move towards the last topic, which will be the reconstitution of authority. So what's going to happen in case of reconstitution of authority? That has been mentioned under section 19 subsection 3. So on or before the expiration of the period of supersession specified in the notification issued under 19 subsection 1, the central government shall reconstitute the authority by a fresh appointment of a chairperson and other members. So fresh appointment should be made for chairperson and other members, and central government is going to reconstitute that authority. And in such a case, the person who has vacated his office, that is the existing chairperson and existing full-time or part-time members, they shall not be deemed to be disqualified for reappointment. So if they wish to, they can offer their candidature again. Okay, that is something which is not being taken from their right as into from their hand. So they in any case shall not be deemed to be disqualified for reappointment. If they wish to, they can apply for their candidature again to work in that office. So that's about the reconstitution of authority. Okay, central government shall reconstitute the authority by a fresh appointment of chairperson and members, and all those persons who have vacated their offices shall not be deemed to be disqualified for reappointment. They can apply if they wish to. This was all about the provisions relating to power of central government to supersede the authority. This is something which is mentioned under section 19 of the IRDA 1999. With this chapter stands complete. Hip hip hooray. Perfect guys, cheers to you. Cheers to you all for your support. Again, another chapter got completed with this. I'll see you with another good kind of topic, another good chapter, a new act in my forthcoming presentation with you guys. Till then, stay blessed, keep loving yourself, keep loving the world, and do revise your topic, because that is something which is extremely important. If in case you have liked our video, do give us a thumbs up with your good comments. It will be really appreciated. I'll be concluding my video with a dose of motivation, and that will be: never let the fear of striking out get in your way. So many of us, like this quote was being mentioned by Babe Ruth, we must acknowledge that person. Never let a fear of striking out get in your way. So it usually happens to us, with us, many of the people around, that we do get fear of many of the things. Okay, a person may have a phobia of like public speaking, a person may have a phobia of like swimming, so many of the times. But herein I'm talking about the fear of taking some kind of action. So the fear of taking actions in order to get successful. So what happens to us is usually get fearful with fact, okay, that we need to make some actions and we need to come out of our comfort zone in order to achieve something bigger in our life. So never let that fear of making you like keep yourself stick to your comfort zone. Don't let that happen. Okay, because that is something which is going to make you discouraged all the time. Okay, you will feel disempowered. So in order to make sure that bring in that spark in you, bring in that confidence in you, and just go and mark and hit to the world. Okay, with each and every kind of action that you are doing, just do it. Okay, that is going to be the best thing which you will be like doing yourself, instead of pondering about the facts or thinking whether I should do, whether I not, where should I do, whether I should not. It's always better go and try it. What worse can happen with that? You get failed, no worries, at least you are making mistakes and learning from them. It's always better to make mistakes and learn from them rather than sitting idle at home and learning nothing. So never let that fear of striking out get in your way. Don't let that. Just move ahead and take actions. That is something which is extremely important. I'll see you in the next presentation. Till then, thank you on behalf of the Edupedia world. Keep interacting via questions, queries in YouTube comment boxes. I will love to help each one of you guys with the queries and nuances that you have for us. Do write to us for that matter. Perfect. Stay connected. That will help us in understanding your needs way, way, way better. Till then, take care. Love you all. God bless you all. See you in the next presentation. Sayonara. Bye.